Kris, let me start by reiterating something you and I have talked about previously, and that's my concern that critical information about the implementation of the PATRIOT Act has not been made public, information that I believe would have a significant impact on the debate. I urge you to move expeditiously on the request that I and others in this committee have made before the legislative process is over. Now, in Suzanne Spaulding's testimony for the next panel, she argues that additional safeguards are needed in the context of intelligence investigations because of the very broad scope of intelligence investigations, the secrecy with which they must be conducted, and the fact that they often do not lead to prosecution. That is, we have to take into account that safeguards inherent to criminal investigations are simply not always present in the context of intelligence investigations. Mr. Kris, do you agree that additional vigilance is needed in the context of intelligence investigations?
Yes.
And in fact, isn't that what was demonstrated, at least in part, by the IG reports on national security letters?
Well, I think the problems that Mr. Fine found are significant. I think they've been remedied. I'm not sure that those are inherent in an intelligence use of NSLs, but I mean, certainly they are significant and they warrant attention, and I think they've gotten a lot of attention.
Mr. Fine, would you agree that the lack of safeguards contributed to the misuse of NSLs?
I think to some extent the fact that they were not transparent does produce an environment where there needs to be more significant vigilance.
Mr. Kris, as you know, the PATRIOT Act provided statutory authority for the government to obtain special sneak and peek criminal search warrants that allow agents to break into Americans' homes and conduct secret searches without telling them for weeks, months, or even longer. It is true, isn't it, that these searches can be conducted also in run-of-the-mill criminal cases and do not require any connection to terrorism?
That's true, both before
and... In fact, according to a July 2009 report of the Administrative Office of the U.S. Courts, isn't that exactly how this authority has most recently been used? The report shows that in fiscal year 2008, sneak and peek search warrants were requested 763 times, but only 3 of those initial requests, just 3, were in terrorism cases. The vast majority were for drug cases. Now, is that your understanding of that report, and does it concern you at all?
It is my understanding, and I want to say thank you to your staff who alerted me and allowed me to read the report in advance of this hearing. It does say here that 65% of these are criminal sneak and peek, were in drug cases. Obviously, just to make something clear, which I know you understand, that on the FISA side, the searches that we do pursuant to FISA are not exactly sneak and peek. They're generally covert altogether. So this authority here on the sneak and peek side, on the criminal side, is not meant for intelligence. It's for criminal cases. So I guess it's not surprising to me that it applies in drug cases.
As I recall, it was in something called the USA Patriot Act, which was passed in a rush after an attack on 9/11 that had to do with terrorism. It didn't have to do with regular run-of-the-mill criminal cases. Let me tell you why I'm concerned about these numbers. That's not how this was sold to the American people. It was sold, as stated on DOJ's website in 2005, as being necessary, quote, to conduct investigations without tipping off terrorists. I'm going to say it's quite extraordinary to grant government agents the statutory authority to secretly break into Americans' homes in criminal cases. And I think some Americans might be concerned that it's been used hundreds of times in just a single year in non-terrorism cases. And that's why I'm proposing additional safeguards to make sure that this authority is available where necessary, but not in virtually every criminal case, and also to shorten the time period for notification.
Well, I don't mean to quibble with you. I do want to just point out one thing, which is I mean, before, and I was trying to carve out FISA, just to clarify that FISA is a different authority where it is covert. And also, if I'm correct on this, I believe 2 courts of appeals prior to the Patriot Act had authorized sneak and peek under existing law. This was,
yes,
I think, meant to be a codification of that
doctrine. Some courts permitted secret searches in limited circumstances before the Patriot Act, as I remember from the debate, but they also recognized the need for prompt notice unless a reason to continue to delay the notice was demonstrated, and they specifically said that notice had to occur within 7 days, which is what we fought for at the time of the Patriot Act, which is what our bill proposes. So I think you make a fair point that it was allowed to some extent, but without these protections, this is a dramatic change in our general criminal law that doesn't necessarily relate to terrorism. Thank you, Mr. Chairman.